Viva Guide on the Code of Civil Procedure. Question: what is decree? Answer: according to Section 2, Subsection 2 of the Code of Civil Procedure, decree means the formal expression of an adjudication which, so far as regards the courts expressing it, conclusively determines the rights of the parties with regard to all or any of the matters in controversy in the suit, and may be either preliminary or final. It shall be deemed to include the rejection of a plaint and the determination of any question within Section 144, but shall not include number A, any adjudication from which an appeal lies, as an appeal from an order, or number B, any order of dismissal for default. Question: who is decree holder? Answer: according to Section 2, Subsection 3 of the Code of Civil Procedure, decree holder means any person in whose favor a decree has been passed or an order capable of execution has been made. Question: what is judgment? Answer: according to the Section 2, Subsection 9 of the Code of Civil Procedure, judgment means the statement given by the judge of the ground of a decree or order. Question: who is judgment debtor? Answer: according to Section 2, Subsection 10 of the Code of Civil Procedure, judgment debtor means any person against whom a decree has been passed or an order capable of execution has been made. Question: who is a legal representative? Answer: according to Section 2, Subsection 11 of the Code of Civil Procedure, legal representative means a person who in law represents the estate of a deceased person and includes any person who intermeddles with the estate of the deceased, and where a party sues or is sued in a representative character, the person on whom the estate devolves on the death of the party or party so suing or sued. Question: what is order? Answer: according to Section 2, Subsection 14 of the Code of Civil Procedure, order means the formal expression of any decision of a civil court which is not a decree. Question: what particulars to be contained in a plaint? Answer: according to Order 7, Rule 1 of the Code of Civil Procedure, the plaint shall contain the following particulars. Number A, the name of the court in which the suit is brought. Number B, the name, description and place of residence of the plaintiff. Number C, the name, description and place of residence of the defendant so far as they can be ascertained. Number D, where the plaintiff or the defendant is a minor or a person of unsound mind, a statement to that effect. Number E, the fact constituting the cause of action and when it arose. Number F, the facts showing that the court has jurisdiction. Number G, the relief which the plaintiff claims. Number H, where the plaintiff has allowed a set of or relinquished a portion of his claim, the amount so allowed or relinquished. And number I, a statement of the value of the subject matter of the suit for the purposes of jurisdiction and of court fees so far as the case admits. Question: what is set off? Answer: according to Order 8, Rule 6 of the Code of Civil Procedure, where in a suit for the recovery of money, the defendant claims to set off against the plaintiff demand any ascertained sum of money legally recoverable by him from the plaintiff. Question: described written statement. Answer: according to Order 8, Rule 1 of the Code of Civil Procedure, the defendant shall, within 30 working days from the date of service of summons upon him, present a written statement of his defense, provided that where the defendant fails for reasonable grounds to file the written statement within the said period of 30 working days, he shall be allowed to file the same on such other day as may be specified by the court for reasons to be recorded in writing, but which shall not exceed 60 working days from the date of service of summons, provided further that If the defendant fails to file the written statement within the said period of 60 working days, the court shall dispose of the suit ex parte. Question: what is pleadings? Answer: according to Order 6, Rule 1 of the Code of Civil Procedure, pleadings shall mean plaint or written statement. Question: who may be joined as plaintiff? Answer: according to Order 1, Rule 1 of the Code of Civil Procedure, all persons may be joined in one suit as plaintiffs in whom any right to relief in respect of or arising out of the same act or transaction or series of acts or transaction is allowed to exist, whether jointly, severally, or in the alternative, where if such persons brought separate suits, any common question of law or fact would arise. Question: who may be joined as defendant? Answer: according to Order 1, Rule 3 of the Code of Civil Procedure, all persons may be joined as defendants against whom any right to relief in respect of or arising out of the same act or transaction or series of acts or transactions is alleged to exist, whether jointly, severally, or in the alternative, where if separate suits were brought against such persons, any common question of law or fact would arise. Question: what is misjoinder and non-joinder? As per Order 1, Rule 9 of the Code of Civil Procedure, no suit shall be defeated by reason of the misjoinder or non-joinder of parties, and the court may in every suit deal with the matter in controversy so far as regards the rights and interests of the parties actually before it. Question: state rejection of plaint. Answer: according to Order 7, Rule 11 of the Code of Civil Procedure, the plaint shall be rejected if the plaint does not contain the following particulars. Number A, where it does not disclose a cause of action. Number B, where the relief claimed is undervalued and the plaintiff, on being required by the court to correct the valuation within a time to be fixed by the court, fails to do so. Number C, where the relief claimed is properly valued but the plaint is written upon paper insufficiently stamped, and the plaintiff, on being required by the court to supply the requisite stamped paper within a time to be fixed by the court, fails to do so. Number D, where the suit appears from the statement in the plaint to be barred by any law. Question: what is stay of suit or res sub judice? Answer: according to Section 8 of the Code of Civil Procedure, no court shall proceed with the trial of any suit in which the matter in issue is also directly and substantially in issue in a previously instituted suit between the same parties or between parties under whom they or any of them claim litigating under the same title, where such suit is pending in the same or any other court in Bangladesh having jurisdiction to grant the relief claimed, or in any court beyond the limit of Bangladesh established or continued by the government and having like jurisdiction or before the Supreme Court. Question: what is res judicata? Answer: according to Section 11 of the Code of Civil Procedure, court shall not try any suit or issue in which the matter directly and substantially in issue has been directly and substantially in issue in a former suit between the same parties or between parties under the same under whom they or any of them claim litigating under the same title in a court competent to try such subsequent suit, or the suit in which such issues has been subsequently raised and has been heard and finally decided by such court. Question: why no party appears before the court? Answer: according to Order 9, Rule 3 of the Code of Civil Procedure, where neither party appears when the suit is called on for hearing, the court may make an order that the suit be dismissed. Question: what will be where only plaintiff appears? Answer. According to Order 9, Rule 6, Sub-Rule 1 of the Code of Civil Procedure, where the plaintiff appears and the defendant does not appear, the suit is called on for hearing. Then, if it is proved that the summons was duly served, the court may proceed ex parte. Number B, if it is not proved that the summons was duly served, the court shall direct a second summons to be issued and served on the defendant. Number C, if it is proved that the summons was served on the defendant but not in sufficient time to enable him to appear and answer on the day fixed in the summons, the court shall postpone the hearing of the suit to a future date to be fixed by the court, and shall direct notice to such a day to be given to the defendant. Question. State a framing of issue. Answer. According to Order 14, Rule 1 of the Code of Civil Procedure, issues arise when a material proposition of fact or law is affirmed by the one party and denied by the other. Question. Describe a procedure of mediation. Answer. According to Section 89A, subsection 1 of the Code of Civil Procedure, except in a suit under the Orturi Nadalat Ain 2003, Act No. 8 of 2003, after filing of written statement, if all these contesting parties are in attendance in the court in person or by their respective pleader, the court shall, by adjourning the hearing, mediate in order to settle the dispute or disputes in the suit, or refer the dispute or disputes in the suit to be engaged pleaders of the parties, or to the party or parties where no pleader or pleaders have been engaged, or to a mediator from the panel as may be prepared by the district judge for undertaking efforts for settlement through mediation. Question. Describe arbitration. According to Section 89B, subsection 1 of the Code of Civil Procedure, if the parties to the suit at any stage of the proceeding apply to the court for withdrawal of the suit on the ground that they will refer the dispute or disputes in the suit to the arbitration for settlement, the court shall allow the application and permit the suit to be withdrawn, and the dispute or disputes thereafter shall be settled in accordance with Salish Ain 2001 so far as may be applicable, provided that if for any reason the arbitration proceeding referred to above does not take place, or an arbitral award is not given, the reinstitute is not given, the parties shall be entitled to reinstitute the suit permitted to be withdrawn under this subsection. Question. Discuss local investigation. Answer. According to Order 26, Rule 9 of the Code of Civil Procedure, in any suit in which the court deems a local investigation to be requisite or proper for the purpose of elucidating any matter in dispute or of asserting the market value of any property or the amount or any man's profit or damages or annual net profits, the court may issue a commission to such person as it thinks fit, directing him to make such investigation and to report thereon to the court. Question. Discuss attachment before judgment. Answer. According to Order 38, Rule 5 of the Code of Civil Procedure, where at any stage of the suit the court is satisfied by affidavit or otherwise that the defendant, with intent to obstruct or delay the execution of any decree that may be passed against him, number A, is about to dispose of the whole or any part of his property, or number B, is about to remove the whole or any part of his property from the local limits of the jurisdiction of the court, The court may direct the defendant within a time to be fixed by it either to furnish security in such sum as may be specified in the order, or to produce and place at the disposal of the court when required the said property or the value of the same, or such portion thereof as may be sufficient to satisfy the decree, or to appear and show cause why he should not furnish security. Question: when temporary injunction will grant? Answer: according to Order 39, Rule 1 of the Code of Civil Procedure, where in any suit it is proved by affidavit or otherwise, number A, that any property in dispute in a suit is in danger of being wasted, damaged, or alienated by any party to the suit, or wrongfully sold in execution of a decree, or number B, that the defendant threatens or intends to remove or dispose of his property with a view to defraud his creditors. The court may, by order, grant a temporary injunction to restrain such act or make such other order for the purpose of staying and preventing the wasting, damaging, alienation, sale, removal, or disposition of the property as the court thinks fit, until the disposal of the suit or until further orders. Question: narrate appointment of receiver. Answer: according to according to Order 40, Rule 1 of the Code of Civil Procedure, where it appears to the court to be just and convenient, the court may by order, number A, appoint a receiver of any property, whether before or after decree. Number B, remove any person from the possession or custody of the property. Number C, commit the same to the possession, custody, or management of the receiver, and confer, number D, confer upon the receiver all such powers as to bringing and defending suits and for the realization, management, protection, preservation, improvement of the property, the collection of the rents and profits thereof, the application and disposal of such rents and profits, and the execution of documents as the owner himself has, or such of those powers as the court thinks fit. Question: narrate the inherent powers of courts. Answer: according to Section 151 of the Code of Civil Procedure, nothing in this code shall be deemed to limit or otherwise affect the inherent power of the court to make such orders as may be necessary for the ends of justice. Question: narrate the procedure of appeal from original decree. Answer: according to the Section 96 of the Code of Civil Procedure, number 1, save where otherwise expressly provided in the body of this code or by any other law for the time being in force, an appeal shall lie from every decree passed by any court exercising original jurisdiction to the court authorized to hear appeals from the decisions of such court. Number 2, an appeal may lie from an original decree passed ex parte. Number 3, no appeal shall lie from a decree passed by the court with the consent of the parties. Question: narrate order from which appeal lies. Answer: as per the Section 104 of the Code of Civil Procedure, number 1, an appeal shall lie from the following orders and save as otherwise expressly provided in the body of this code or by any law for the time being in force from no other orders. Number F, an order under Section 35A, G, an order under Section 95, an order H, an order under any of the provisions of this code imposing a fine or directing the arrest or detention where such arrest or detention is in execution of a decree. Number I, any order made under rules from which an appeal is expressly allowed by rules. On the other hand, orders stated in Order 43, Rule 1 of the Code of Civil Procedure are also appealable. Question. Describe review. Answer. According to Section 114 of the Code of Civil Procedure, any person considering himself aggrieved, number A, by a decree or order from which an appeal is allowed by this code, but from which no appeal has been preferred. And number B, a decree or order from which no appeal is allowed. Or number C, by a decision or on a reference from a court of small causes, may apply for a review of judgment to the court which passed the decree or made the order, and the court may make such order thereon as it thinks fit. Question. Describe civil revision before the High Court division. Answer. According to Section 115, subsection 1 of the Code of Civil Procedure, the High Court division may, on the application of any party aggrieved, call for the record of any suit or proceedings in which a decree or an order has been passed by a court of district judge or additional district judge, or a decree has been passed by a court of joint district judge, senior assistant judge or assistant judge, from which no appeal lies, and if such court appears to have committed any error of law resulting in an error in such decree or order occasioning failure of justice, the High Court division may revise such decree or order and make such other order in the suit or proceedings as it thinks fit. Question. What is leave for revision? Answer. According to Section 115, subsection 4 of the Code of Civil Procedure, an application to the High Court division for revision of an order of the district judge or additional district judge, as the case may be, made under subsection 2 or 3 shall lie where the High Court division grants leave for revision on an application to the High Court division for revision of an order of the district judge or additional district judge, as the case may be, made under subsection 2 or 3 shall lie where the High Court division grants leave for revision on an error of an important question of law resulting in erroneous decision occasioning failure of justice, and the High Court division may make such order in the suit or proceedings as it thinks fit. Question. Civil jurisdiction of the High Court division. Answer. Appellate jurisdiction and revisional jurisdiction. Civil appeal. First appeal, second appeal, miscellaneous appeal, cross appeal, appeal under special law. First appeal. Appeal from decree under Section 96 to 99 of the Code of Civil Procedure is called first appeal. Second appeal. Law Reform Ordinance 1978 had omitted Section 100 to 103. That's why the form of second appeal is abolished. Miscellaneous appeal. Apart from order under Section 104 to 106 of the Code of Civil Procedure, an appeal under special law is called miscellaneous or misappeal. Cross appeal. In cross appeal, the decree of the lower court is partly in favor of and partly against the respondents, in which case both of the appellant and the respondent may separately appeal to the High Court to set aside that part of the decree which affects him adversely. These two appeal is cross appeals. Memo appeals. Order 41, Rule 1 of the CPC provides that every appeal shall be preferred in the form of a memorandum signed by the appellant or his pleader and presented to the court or to such officer as it appoints in his behalf. Paper book. Paper book is must in both civil and criminal appeal. In civil plaint, issue, judgment, and decree, memorandum of appeal, index, etc. Limitation period of civil appeal. According to Article 156 of the Limitation Act, to file a civil appeal before the High Court division, limitation period is 90 days. On the other hand, to file a civil appeal before the judge court, then the limitation period is 60 days. Thank you, viewers.